Hello, and welcome to the View from Mayor Brown podcast. This is a fortnightly podcast series for employment lawyers and HR practitioners, which highlights developments in case law and legislative changes of importance to UK employers. It is presented by Nicholas Robertson, the head of Mayor Brown's London employment team. The time spent listening to these podcasts can count towards your training requirements. At the end of the podcast, we will explain how to get in touch if you have any comments or questions.
Hello and welcome to podcast number 137. I hope everyone had a good summer. I'm back after almost 3 weeks out of the office, which involved a short visit to Toronto, Cambridge Folk Festival, and then 2 weeks in Italy. I am inevitably going to talk about the Cambridge Folk Festival at the far end of the podcast. But anyway, after the one-off podcast, which was the discussion with Jennifer McGrandle about ELIPS and the assistance it provides tribunal litigants in person, and by way of detour, if you've not yet heard the podcast, I'd strongly recommend it. The ELIPS initiative is a fantastic initiative and one we should support. Anyway, I've got the usual three cases for you. First case is in relation to voluntary overtime and the Working Time Directive when it comes to calculating holiday pay. The second is on philosophical belief, and possibly a rare case where the tribunal declined to accept that something amounted to a philosophical belief, such as to grant protection to an employee. And then thirdly, we've a useful, although I don't think groundbreaking case on the dismissal of an employee who is disabled and absent on long-term sickness. As always, please don't forget you can access the podcast through our website, LinkedIn, iTunes, YouTube, and all the links to the cases go out on Twitter. So, first things first, Flowers and Others and East of England Ambulance Trust. Do you have to take voluntary overtime into account when calculating holiday pay? Well, the facts of the case are pretty simple. The claimants all worked for the respondent in connection with the provision of ambulance services. The issue related to the calculation of holiday pay in accordance with their contract, but also calculated in accordance with Article 7 of the Working Time Directive. Although part of the EAT case was taken up with the interpretation of the contract of employment, I'm going to focus primarily on the Working Time Directive aspect of the case, but I'll mention the contractual sting in the tail. The issue, of course, was how the holiday pay was to be calculated, and in particular, whether two types of overtime pay were to be taken into account when calculating holiday pay. One type of overtime payment was non-guaranteed overtime, and then there was a second type of overtime payment which was called voluntary overtime. The non-guaranteed overtime related to shift overrun payments. In other words, if an individual was partway through a task, and when their shift ended and they were expected to finish that task before they were allowed to go, they were paid an overtime rate until that task was finished. The second type of overtime, voluntary overtime, was exactly what it says on the tin, completely voluntary. There was no obligation on the trust to offer or on the individual to undertake it, and the agreed statement of facts, for example, accepted on behalf of the claimants. The individuals were, quote, completely free to choose whether or not to work any voluntary overtime shifts, unquote. Well, the claimants brought an employment tribunal claim in which they said that both types of overtime pay should be taken into account in calculating holiday pay. Since the employer was an emanation of the state, the claim was a working time directive claim rather than a working time regulations claim, although I don't think that would have made any material difference to the outcome if the employer had been a private sector employer. Well, the trust conceded that the first category of overtime pay, the non-guaranteed overtime, should be taken into account when calculating holiday pay under the Working Time Directive, and the tribunal said this concession was clearly correct. And it is, in the light of the Bear Scotland Limited and Fulton case, all the way back in 2015. But the employer argued, and the employment tribunal accepted, that voluntary overtime was in a totally different category. Since there was no contractual obligation on the claimants to undertake the voluntary overtime, it was different in nature. And they said, in their view, it did not form part of the pay for calculating annual holiday leave pay. Well, we then had the EAT's decision in Dudley, Metropolitan Council and Willits, where the EAT held that voluntary overtime could fall within the Working Time Directive concept of normal remuneration. As such, the claimants in the Flowers case appealed, and the issue for the EAT here was whether the Dudley case was effectively decisive. And in short, the EAT accepted that Dudley approach did mean that voluntary overtime could be included when calculating holiday pay. This is on the basis, in line with the Dudley case, the right to paid annual leave is a particularly important part of EU social law. The overarching principle is that the normal remuneration should be maintained for holiday pay, so that a worker is not deterred from taking holiday by having to accept a pay cut as a result of taking that holiday. In the light of that, overtime payments, whether compulsory, non-guaranteed or voluntary, constituted remuneration, and if they'd been paid over a sufficient period of time and regularity, they would amount to normal remuneration, and it's normal remuneration that has to be taken into account in calculating holiday pay. So here, the EAT declined to accept the arguments that were put up by the employer, saying either Dudley was wrongly decided or it could be distinguished. And the EAT in particular upheld the Dudley analysis that it was an overarching principle designed to ensure that workers were not deterred from taking holiday by accepting less than their normal remuneration as a result. On that basis, the claims went back to the Employment Tribunal to decide whether the overtime payments that had actually been made were sufficiently regular to constitute normal remuneration. And that's obviously going to be a very fact-specific exercise, but you'd certainly hope that we will see in practice guidance on what amounts to a sufficiently regular set of payments that qualify to be taken into account when calculating holiday pay, so that employers aren't having to rely on the employment tribunals to make a series of rulings in each and every case. I think the case is an important one, and it represents a further victory for workers trying to ensure that holiday pay takes into account that the payments that they have received sufficiently regularly for working, irrespective of the way those payments are in theory categorised in the tribunal: guaranteed, non-guaranteed, guaranteed if requested, etc., etc., voluntary overtime. The other thing I said, you remember I said at the start of this that the individuals are also making claim directly under the contract of employment. Now I assume this is because that would enable them to claim that all of their holiday pay ought to be enhanced by taking into account voluntary overtime. This would not just be limited to the so-called Euro leave period, which is 4 weeks leave, as per the directive, rather than the full holiday leave period specified in the contract. However, the EAT, for reasons I don't need to go into in detail here, decided the contract itself could be interpreted so as to require individuals to be paid holiday pay, including sums in respect of voluntary overtime pay. And as such, I think there's a bit of a sting in the tail for this particular employer. If I'm right, it means that the impact of the finding is, I think, going to be rather more significant than just applying to the Euro leave holiday pay. Employers who are looking at addressing a similar issue then need to be aware that it may not be possible for them to differentiate between Euro leave, where voluntary overtime etc. will have to be taken into account if paid sufficiently regularly, and the remaining holiday leave given under the contract of employment. This is all going to depend on how the contract of employment is written. I'm also not certain how many employers are going to want the added complications of paying out holiday at 2 different rates, but that's obviously a commercial matter rather than a legal one. So, that's the case of Flowers and Others and East of England Ambulance Trust. In short, voluntary overtime, if paid sufficiently regularly, is going to need to be taken into account when calculating holiday pay. So, next up, Ali and Tarosian and Others. What happens if an employee is on long-term sickness absence and an employer dismisses him without considering whether that employee could have worked on a part-time basis instead? And the case, in effect, concerns Section 15(1)(b) of the Equality Act 2010 and the dismissal of an employee who it was clear was never going to work again on a full-time basis. The individual had worked as a GP for the Bedford Hill family practice. He was on long-term sickness absence after he'd had a heart attack. It was clear he was a disabled employee. The medical evidence which he put forward to the Bedford Hill family practice indicated he would not work again full-time, but did raise the possibility he would return on a phased basis, taking up part-time work. However, after suffering a further and I think unrelated injury, he was then dismissed by the Bedford Hill family practice on the expiry of the sick note relating to the shoulder injury, the unrelated injury. And ironically, they did not follow up in any sense the suggestion that he could work on a part-time basis. They effectively seem to have ignored the medical advice. Oh, the irony. Well, he claimed unfair dismissal and that he'd been discriminated against unlawfully contrary to Section 15(1) of the Equality Act 2010, i.e. he'd suffered discrimination arising from his disability. The legislation provides, in short, if A treats B unfavourably because of something arising as a consequence of B's disability, and A's treatment is not a proportionate means of achieving a legitimate aim, then the discrimination claim is made out. Of course, here he was being dismissed because he was absent from work by reason of his ill health, which amounted to a disability. Therefore, he was being treated unfavourably because of something arising as a consequence of his disability, and the question in effect for the tribunal was whether the treatment was a proportionate means of achieving a legitimate aim. Of course, the process of showing whether or not treatment is a proportionate means of achieving a legitimate aim involves a balancing exercise. The unfavourable treatment in question has to be an appropriate means of achieving a legitimate aim and a reasonably necessary means of achieving that aim. And the tribunal will end up looking at balancing the needs of the business against the discriminatory impact of the employer's actions. In deciding whether or not something is proportionate, it's well established that the tribunal should look at whether a less discriminatory route or action would still achieve the employer's aim. If that is the case, then it's unlikely to be proportionate to adopt a more discriminatory provision than necessary. Well, here, the Employment Tribunal decided that the dismissal was procedurally unfair. Having been told by Dr. Ali's medical advisor that he would be capable of working part-time, the Bedford Hill family practice had failed to have any discussions with him about that possibility. However, the tribunal turned down the disability discrimination claim on the grounds that the family practice had justified the dismissal because it was a legitimate aim of ensuring that the patients at the practice had the best possible care. Well, the case went to the EAT, which upheld Dr. Ali's appeal. His argument was very simple. If his dismissal was unfair on procedural grounds because there had been a failure to discuss even the possibility of part-time working, then the tribunal should have gone on to consider whether this failure to consider part-time working also meant that dismissal was discriminatory. If part-time working was feasible and would have achieved the family practice's objective of providing the best possible medical care, they would not be justified to dismiss Dr. Ali to achieve that objective. It would not have been necessary to do that. The EAT agreed. If part-time working would have been feasible, then it would not be justified to dismiss someone in pursuit of a legitimate aim, when the same legitimate aim could have been achieved in a less discriminatory fashion, i.e. offering part-time working rather than dismissal. Now, the case report is slightly unclear. It's not certain to me whether the Employment Tribunal found as a fact that part-time working was actually feasible, or whether the tribunal talked about it in more general terms as a possibility. And I think the EAT likewise had some uncertainties about that, because the matter was sent back to the tribunal to consider the issue of part-time working and its feasibility, etc. I think the case is a useful reminder that an employer needs to consider whether there is a lesser measure available which would still achieve the particular legitimate aim. Here, and with the benefit of hindsight and the facts as found by the Employment Tribunal and then commented on by the EAT, it does seem obvious that the possibility of part-time working should have been in play, whether or not it was actually going to turn out to be feasible. As such, it's not a great stretch to indicate that the employer may have overstepped the mark by failing to consider or discuss part-time working with an individual who has been medically assessed as able to return to work on that basis. However, I think the principle of the case goes further. In other words, I think that claimants facing dismissal following a prolonged period of absence will rely on this case to say that the employer should, in any event, consider part-time working as an alternative to dismissal. It's not necessary that it's flagged up by the medical evidence. Obviously, in some cases, the answer may be completely clear-cut. The individual is simply not able to return to work at all, at which point this case goes away. But I think the principle of the case applies equally, even where a claimant has not said they're able to return to work on a part-time basis, but the employer fails to consider part-time working, even on a preliminary basis, if only to satisfy itself that part-time working is utterly impossible, either because there are no opportunities to have part-time working, or the employee's health is such as part-time working is as impossible as full-time working. So, that's Ali and Tarosi and others, an employer who dismisses an employee on long-term sickness absence who is disabled, where the employer fails to consider whether a suitable alternative to dismissal exists, is adopting a risky approach. Third, Gray and Mulberry Co. Design Limited. The case deals with an individual's right to be protected against being discriminated against on the grounds of a religious or philosophical belief held by that individual. Claimant signed up for work for Mulberry. She started in January 2015. Her work involved her having access to Mulberry designs ahead of their launch to market. Unsurprisingly, there was a contract and there was an IP agreement, and there were extensive clauses dealing with inventions, improvements and patents in the contract of employment and the IP agreement. These covered copyright work and designs, moral rights, etc. during her period of service with Mulberry, and that these things all belonged to Mulberry. Claimant signed the contract of employment in January 2015, but not the linked IP agreement, because she said it would interfere with her own work as a writer and filmmaker. Mulberry said in response they had no interest in her work as a writer and filmmaker, and so they amended the IP clauses that made it clear that the copyright, etc., covered by the agreement had to relate to the business of Mulberry or a matter arising from her employment with Mulberry. But the claimant still refused to sign up, claiming the additional words were general and open to interpretation. Eventually, matters got to the stage that Mulberry clearly lost patience, and she was dismissed in September 2015, i.e. 9 months or so later, because she'd still refused to sign the IP agreement. Claimant sued, and by the time the case got to the hearing at the Employment Tribunal, her claim was that she'd been directly or indirectly discriminated against on the grounds of her belief, i.e. her statutory human or moral right to own the copyright and moral rights of her own creative work and input, and that this right had been infringed by requiring her to sign the IP agreement or face dismissal. The Employment Tribunal turned down her claim, and so she appealed to the AT. Section 4 of the Equality Act provides a list of protected characteristics, and this includes the characteristic of religion or belief. And now, the definition of belief is set out in Section 10, and that is any, quote, religious or philosophical belief, unquote. The Code of Practice from 2011 on the Equality Act provides some additional guidance on how to establish whether or not something is a belief protected by the legislation. For example, to qualify, a belief must be genuinely held by the claimant. It must be a belief, not an opinion or viewpoint based on the present state of information available. It must be a belief as to a weighty and substantial aspect of human life and behaviour. It has to attain a level of cogency, seriousness, cohesion and importance, and it must be worthy of respect in a democratic society. In front of the Employment Tribunal, the employer challenged whether the fourth ground was met, i.e. it said the claimant's belief did not attain the necessary level of cogency, seriousness, cohesion and importance, and the Employment Tribunal agreed, dismissed her claim and accepted she had not been directly discriminated against. She can be dismissed for failing to sign the agreement, and that refusal by itself did not manifest her particular alleged belief. They also dismissed her indirect discrimination claim because there was no indication that there was a group of people who would be disadvantaged by the requirement to sign the IP agreement. In any event, it was justified for Mulberry to require her to sign the IP agreement. While she strongly believed in the right of ownership to her creative output, it was not any sort of philosophical touchstone to the claimant's life. At the EAT stage, the employee said that the Employment Tribunal had set the bar too high, trying to establish whether her beliefs met the necessary levels of seriousness, cohesion, cogency, importance, etc. And the EAT accepted it wasn't for the tribunal to judge the validity of the philosophical belief, but it was important to look at the manifestation of that belief in this context. Here, the EAT asked itself whether failing to sign the IP agreement was a direct expression of the claimant's views on IP rights. The Employment Tribunal had accepted that the failure to sign the agreement did not amount to a manifestation of the claimant's belief in the right to own copyright. Her only stated reason at the time for refusing to sign was that the respondent would have claimed rights over her own private creative output. There's no suggestion the refusal was motivated by a philosophical belief, and the mere fact of her refusal to sign would not have indicated to the employer she was manifesting such a philosophical belief. The objections she put forward were, in the words of the EAT, quote, purely commercial, designed to protect her private interests, i.e. her ability to sell on her privately created work, unquote. Therefore, the EAT accepted that the tribunal had been entitled to come to the view that the claimant's beliefs were not sufficiently cohesive to form any cogent philosophical belief system, and the indirect discrimination claim was similarly dismissed. I wanted to include the case because it's an indication of the ambit of the philosophical belief provisions. I suspect, although of course we have no way of knowing from the case report, that when the employer dismissed the employee on the grounds that she had deliberately failed to sign the IP agreement, they would have been surprised to learn that they would end up in the EAT on a case involving the interpretation of the philosophical belief provisions under Section 10.2 of the Equality Act 2010. However, here what I think sank the claimant was that she did not articulate her objections at the time as being based on a philosophical belief about the ownership of copyright. Equally, though, I think it would be unwise for an employer to assume that in the absence of any such express articulation, a claimant will always lose a similar case. If it had been obvious from the behaviour of the individual that what underlay his or her actions was a philosophical conviction, the employer would at least have been placed on notice of that belief. The employee failed here in her argument that the failure to sign the agreement necessarily manifested the philosophical belief. But if it is an indication, that this is an indication, I think, this case, that Even though here the employee lost, you do need eyes in the back of your head when it comes to identifying potential claims arising out of alleged adverse treatment on the grounds of an employee's philosophical belief. So that's Gray and Mulberry Code Design Limited, and in short, that employers need to be alert to the law protecting an employee's philosophical belief, because those claims can come at you from unexpected angles. So, thank you very much for listening. I said I'd say just a few words about the Cambridge Folk Festival. I can't resist it. You're getting off lightly because I've been to a number of other festivals which I haven't banged on about. But anyway, Cambridge Folk Festival was wonderful. Thoroughly enjoyed it. Highlights, and I'm pretty sure I've mentioned both these acts before on the podcast. The First Aid Kit were stupendous, and if anything, Rhiannon Giddens was even better. And David, who I went to the Folk Festival with, came away saying he thought the Rhiannon Giddens Things was one of the best live music shows he'd ever seen, which is high praise indeed. Anyway, now I'm back from holiday, we're back into the regular swing of things, and so work permitting, look forward to doing podcast number 138 in a couple of weeks' time. Until then, stay safe. Thanks for listening.
So that was our latest podcast. We hope you found it useful. If you have any questions or comments, please email Nick on nrobertson@mayorbrown.com. Our podcasts are an overview of cases. How the law applies in any particular case will obviously depend on the individual circumstances, so please take legal advice if any of the matters discussed are relevant to issues that you are dealing with. And thank you for listening.